ready to start? All right, we're rolling. Good afternoon, I'm Randy Carter. I'm a disappointed participant in Oklahoma's Responsible Transportation. I am quite disappointed about the Supreme Court ruling today, and we have some comments from some of our cohorts, and I'd like to start off by, I have not read the complete ruling, so I'm not even a minor expert in that at this point, but I'd like to introduce Amy Serrato, who is President of Pike OTA and Oklahoma's Responsible Transportation. She has some remarks about our feelings concerning the Supreme Court ruling that came down today, very much to our disappointment, authorizing the bonds. So Amy, if you'll come up and share your remarks with the press.
Okay, for once in my life, I don't have prepared remarks. We had a big press conference this morning up at the Oklahoma Department of Transportation building because the Oklahoma Turnpike Authority would not let us speak to the board. They said that their agenda items were not indicative of something that we needed to have comments on, and of course, that's just how they always play things. They don't want to have public discourse. And then when we moved to the Oklahoma Turnpike Authority board meeting this morning, we found out that the state Supreme Court had indeed levied their opinion. And Pike OTA and the Oklahomans for Responsible Transportation, and me personally, are very disappointed in that Supreme Court decision. It eviscerates any ability for the citizens of the state of Oklahoma to bring issues and ask questions about the legislative authority of the Oklahoma Turnpike Authority. In fact, this decision has made it a precedent that the Oklahoma Turnpike Authority can now build wherever they want, whenever they want, regardless of what is in Statute 69, Section 1705. They cited, the majority opinion of the state Supreme Court cited that the southern extension was clearly written in the statute. And I would say that that is a completely intellectually dishonest statement. There's no way that you can decipher the southern extension from that statute. And in fact, you cannot even decipher the east-west connector or the Tri-City connector, in that the Oklahoma Turnpike Authority was required to build that outer loop with one bond issue, and they did not. And one thing stood out to me in the majority opinion, and let me find that for you, because I was quite disturbed that the state Supreme Court would actually say this, because it either points to their lack of intellect or in fact their lack of intellectual honesty. They said, "We have opined that an agency's own consistent administrative interpretation for a period of over 20 years must prevail over a contrary interpretation suggested for the first time." Meaning that the OTA acted illegally several times and got their illegal kickapoo, but just because we brought the fact that they shouldn't have been allowed to build that, they can still continue to do their illegal actions. And I think that that just speaks to the fact that the majority of the state Supreme Court doesn't fully understand the issue, or they understand it. They're just better friends with the Oklahoma Turnpike Authority and their cohorts than maybe we have the ability to be. And so I would encourage everybody to read the dissents. We are appreciative of Supreme Court Justice Kuhn and Supreme Court Justice Rowe and Hickson for dissenting and basically stating, and I'll read to you from one of the dissents, that basically saying that the majority's decision confers upon the OTA incredibly broad discretion without any cognizable limits, meaning that they can build wherever they want, whenever they want, even outside of that, the written Turnpike Enabling Act. And the OTA is apparently free to blatantly disregard the legislator's directives with respect to routes and funding. And so I want you to be sure that this fight is not over for us. We have a very strong legislative group, and we are going to make sure that every single legislature knows that the Oklahoma Turnpike Authority is not paying attention to the Turnpike Enabling Act, and that we need to put some serious protections in place for the citizens of Oklahoma. Not only that, but we have great faith in the Attorney General's audit that is being called. We have already found allegations and evidence of some interesting financial maneuvers within the Oklahoma Turnpike Authority payment registers and have turned that over. Not only are we seeking help at the state level, but Pike OTA will be seeking help at the federal level for these allegations. And we hope that we are able to take these two court cases, the Oklahoma Open Meetings Act and the authorization case, the bond validation case, to the federal courts. I thought that it might be interesting just to point out that Oklahoma is not unique, unfortunately. This book, When the Levee Breaks, talks about the Pennsylvania Turnpike, the patronage crisis, and the state Supreme Court. And in this book, it talks about how the Turnpike Authority has been allowed to act and what the rulings have been. And I would point you to the beginning of chapter 10, where an insider states that you should file a suit in federal court, there's no use going through the state courts. And then the author asked, why not? And then the insider smiled, because State Supreme Court Justice Sapala is on the Supreme Court. His brother's the Turnpike bond dealer. Justice Sapala is the Turnpike's judge. And I would argue that the same thing happens in the state of Oklahoma. In fact, we know that there's conflicts of interest between some of the state Supreme Court justices. They should have recused themselves before levying an opinion on the Open Meetings Act and this current case. And so I know everybody is disheartened, but I will tell you, as someone who's been fighting this for 15 months, when the original Southern Extension route was slated to take out my living room and all my 10 acres, that I will continue to stand with you and fight, because we don't lose until we stop fighting. And this is not over. Hi y'all, come on in. This is not over. We have legislative maneuvers to make. We have audit maneuvers to make. We have just received open record requests from the governor's office that show conclusively that state agencies have been socially listening and plotting and summarizing our activities on the taxpayer dime that we will be putting out to press. And there's lots of things that are happening that we need the citizens to stay involved with, and we need help with sharing that message, because the Oklahoma Turnpike Authority does not conduct business in an ethical way. And I know that Tassie will come up and talk a little bit more about the corruption and collusion, because she's the expert in that area, but I will tell you that just because the state Supreme Court ruled in the way it did, doesn't mean that the federal court will follow along. And so we need to stand our ground. Please don't make any deals with the Oklahoma Turnpike Authority. Pike OTA is here to help, and we're here to make sure that East Norman and North Norman stays in the same way that we want it to stay. That's why we moved out there, and that's how we want it to stay. And so I have anything that you want to ask me, I can get you information on. I think we'll probably do questions at the end.
Yeah.
And then I have Rob Norman's speech.
Yeah.
Do you want to do that later?
Let's do that. Let go.
Okay. But I want to just remind you to keep the faith. This fight is not over. We have a strong group, 12,000 strong in the No More Turnpikes group, and our legislative committee has been doing fantastic work. We're making inroads by educating all Oklahomans that nobody actually owns property in the state of Oklahoma anymore, because the Oklahoma Turnpike Authority has the ability to drive over anyone's house whenever they want, and that's not okay. So we need to continue to make changes so that our children and our grandchildren don't have to deal with the Oklahoma Turnpike Authority when they get to our stage. Okay? So thank you very much.
Hear, hear.
Thank you. I would like to introduce our next speaker, Tassie Hirschfeld. Tassie, come up. Tassie is also a professor, PhD professor at the University of Oklahoma, and we'll let her tell you her story.
Thank you. And thanks to everybody for coming out. It's
like Dr. Serrato, I do not have formal remarks prepared. I had some for our first press conference, and then this news dropped. It's like I have no ability to make new remarks, but I do have some thoughts that I would like to share with you. First of all, my immediate response on hearing the news and then reading the ruling and having a little ice cream and thinking about it and talking to my dogs was that I genuinely feel that the majority in the state Supreme Court has profoundly embarrassed itself with this ruling. I feel that the dissenting opinions accurately portray the reality of the situation and recognize the gravity of what has just been allowed to happen. I feel like we all intuitively sense that at a certain point, but I don't know that we've all fully processed what it means. So I'm going to read one or two sentences from you from this dissenting opinion that I think is the most important lesson that we should all hold with us as we make our plans to go forward. So this is from, my little screenshot doesn't have which justice, but we can figure that out later. It says, no other agency, entity, or branch of government is charged with oversight of OTA. That's what this ruling does. It validates the fact that OTA's legal argument in both the open meetings case and all of the other cases was we can do whatever we want. We make our own rules. The highways go where we want them to. And if we authorized a route 30 years ago and decide to build it, but it is now 15 or 20 miles away from that original route, that's what we're allowed to do. And that is what the Supreme Court has said is okay, the majority. Obviously, it's not okay, at least not with this room, or none of us would be here. And so what does this mean for us going forward? Well, I think for me, I feel like the most important message I have to share is with people who are not in our group, because they don't know what it means for them yet. And what this ruling means for them is they do not own their homes, or they're just temporarily staying there until the Turnpike Authority or a real estate developer, for instance, on the State Transportation Commission, or a real estate developer on the Turnpike Authority Board thinks that land looks like it might appreciate a whole lot. Maybe it's time to put a turnpike there, and then we can get all those people off that land and we can flip it very conveniently to people that we think are our friends and acolytes. That's what that means for everybody in the state now. We've seen this happen locally and with Kickapoo, and it's grown bigger with Access Oklahoma. If they are actually able to get $5 billion of bond money, then this is going to become the new model for transportation planning for the entire state. Unless something dramatic changes, and the only potential for change immediately I can see is at the state legislature. And so I just want to encourage everybody, if you have friends that live in other communities that feel like this is just a Norman issue, it's not. If you have friends that live in other communities that are like, well, maybe it'd be nice to have a highway closer by, well, we respect that, but with this process, that's not what you're going to get. What you're going to get is a slipshod agency with no oversight, an unlimited budget, and the ability to seize any parcel of property that it wants at any time for any reason. And I'm going to assume that most Oklahomans are not okay with that. And so now's the time to organize and make those feelings known to people who can do something about it. Thank you.
Yes.
Good, sure.
Do you want to?
Yes, actually I can. As you know, like many of us in higher ed, like I immediately would get into professor mode and be like, let me give an hour-long lecture with some slides. That's not what we're here for today. But the other element of this that I also feel like is really important to talk about is conflicts of interest at the Supreme Court. If there is even a perception of a conflict of interest, that judge is supposed to recuse. That has not been a problem for the judge who authored this majority opinion in the past. His wife is Susan Winchester, who is a very well-regarded public figure in the state of Oklahoma, that she has been for a long time served as head of the research arm of the State Chamber of Commerce. I believe the State Chamber has been a vocal supporter of Access Oklahoma all along. Right before Access was announced, they released a big report called Mega Projects and things that combine infrastructure and tech. I personally believe that Access Oklahoma fits that model, and that the State Chamber has probably played a much greater role in helping develop Access and selecting the routes and viewing this, because their language is always that this is about development. Well, I mean, we're all for development. However, there needs to be a process that respects homeowners, communities, city planning, watersheds, and none of that has happened here. And so my personal request would be that Judge Winchester recuse from any further deliberations or future hearings regarding these issues. In a published interview conducted by Oklahoma State, I don't remember in which year, it was a long, nice narrative interview with Susan Winchester where she was asked, like, how do you negotiate when your work in the legislature looks like it might conflict with Judge Winchester's work at the Supreme Court? She said, oh, we just recuse, it's no problem. Well, I feel like now is a good time to remind her of those words and to remind him of those words, because this is really, again, in my opinion, a profound embarrassment for the state.
Thanks, Tessie, you did fail to mention that Susan Winchester is on the governor's cabinet.
Yes,
And this project from the very beginning has been driven by the governor. We've called it his baby from the very beginning. So just wanted to point that out. Amy, do you want to come up and, Rob Norman, the lead attorney for Pike in the bond authorization case, he pled the case before the Supreme Court, was unable to make it today, but he has submitted a statement, and Amy's going to read that for the benefit of the media.
Okay, so this is from Rob Norman, and he says, we're obviously disappointed in the majority decision. The dissenting opinions provided a convincing, well-reasoned explanation of why the new turnpikes clearly exceed the critically important guardrails the legislature has placed upon the Turnpike Authority. Justice Rowe convincingly pointed out the dangers of today's decision. It essentially gives the OTA incredibly broad powers without known limits, and the OTA now appears to be free to blatantly disregard the people's elected representatives. We will continue our fight to vindicate the rule of law, our cherished civil rights, and representative democracy. We must return our government to the people. We must never yield to the rule of a few unelected bureaucrats and narrow special interests who seek to exercise unlimited power at the expense of all of us. And I echo that statement for sure.
Why don't you stay up here? If anybody has any questions, Tessie, you want to come up too? We'll open it for questions from the media or anybody else. Yes.
Indy Wood, Norman Transcript. I just wanted to make sure that we're clear that this group is intending to file federal lawsuits against the Turnpike Authority or against, can you clarify?
Well, we haven't spoken with our lawyers yet, but we were encouraged in the state Supreme Court Justice Coon's dissent that the only way that we get anywhere is to have federal knowledge. And we knew that. There have been lawyers that told us that we needed to go federal from the beginning, but we had to start at the state somewhere, because the federal court system would have just sent us right back down to the state until we exhausted every single avenue at the state. And so I would like to see Pike OTA and the Oklahomans for Responsible Transportation make that leap into the federal court. Now, that being said, we would need a significant amount of support to make that happen. But I think that we have enough legal minds in the state that are willing to help, that we would be probably wildly successful with that endeavor.
So to say, yes, we're going to explore the idea of
Right.
involvement.
Janelle?
I don't want to feel like this is a power struggle, but it almost is starting to make me believe that. And I'm wondering if by chance there would be any benefit to us to make this a national known story that is happening in our state. Are we just going to keep it within our borders and not let other people know what a travesty this is, what an atrocity this is for us? If we have connections to any outlet in any state. I mean, I do. I have one in ABC News, National News. I have a contact. I have one in Dallas. I'm not going to do anything without our agreeing that that might be a good idea.
Well,
But-
it'll be a good idea. We love it. We have had some contacts with media nationally, and up to this point, it's all been going on in the state. So yes, we certainly will explore those avenues. So yes.
And when I first explored that, my reaction from my friend in Dallas was, I will run this by my boss. Well, that was at the beginning. There's so much that has been transpiring since then that I think would awaken a lot of this country to what our government is actually capable of doing
Yeah, and
to
we-
our homes, our peace.
And we have the documentary that's almost done, that Josh has been
Yes.
shooting, and he just recently moved to New Hampshire. But once we release that documentary and have everybody come, we're either thinking the Sooner Theater or somewhere, we're gonna have a big media, watching, and we're gonna try to get that picked up by Netflix or, a national media that will put our story out there, and then possibly we'll get some interest from around the country, especially with these new open record requests that are coming out of the governor's office. I'm sure the national news will be super interested to hear what spying has been going on the Oklahoma citizens.
And I'll add too, and the press conference we did this morning, I prepared a statement as if things I would like to say to the OTA board, but that they obviously were not inviting me to say, but it had to do with the Turnpike Authority not being a good investment partner for any banks that may be thinking about helping them get these bonds. And I have a long list of reasons why that is. Most importantly, like if you were to look at any, you can even Google this, top 10 red flags for potential fraud and corruption in an organization. There's no fraud reporting hotline. There's a culture of secrecy and insularity. And so with a pending investigative audit, like a sensible bank would be like, I might wait a little bit. And so also bringing this information out, I think is going to be very beneficial.
You have 20 days to petition the Supreme Court. Do you plan to do that?
We're exploring that. I suspect we probably will. Is that a
We
good
did
answer?
that. We did that with the Open Meetings Act case, and so I'm assuming we will do that with this case as well.
We just found out about this a few hours ago,
Yeah.
so we really haven't had a lot of chance to
Yeah.
do a lot of specific planning, but that certainly is in the ballpark.
First, reading the opinion, it seemed like the dissenting judge gave us a foundation. If I understand the opinion, he stated that the courts had no option because this was an administrative ruling, not a judicial ruling, not based on a court case of fact. That's my interpretation. Of that, he laid out a foundation of a judicial challenge, when I was reading into the facts there. But one of the things I also read there, if I'm incorrect, he also stated that we had no federal foundation, no basis on a federal case, based on what he was reading there, because there was no federal funds that involved this. Maybe I misinterpreted what I read there.
In State Supreme Court Justice Kuhn's dissent,
I mean, one of them, he stated because there was no federal funds, effectively had no basis, that federal, obviously I'm not counsel, but that's what I read there.
I'm not a counsel either, but I would think that the federal court system wouldn't be affected by the source of funds if it's a constitutional question. So-
I would add, I'm sorry, I didn't mean to interrupt.
Yeah.
So if they try to get bond funding, they have to disclose like municipal bonds are for municipalities for public good. But OTA has done no traffic or safety studies for these routes. And so for them to try to put a bond prospectus together, they're gonna have to be like, yeah, this is for safety. That was apparently, the theme at the OTA press conference this afternoon, the rationale for these highways. But they have not done this. And so that is another potential area for federal intervention. If they are misrepresenting things in these bond disclosure documents, that's a securities violation.
And then the additional question, if I understand correctly, there will be a new board appointed November 1, is that correct?
No, that is not correct. You're speaking about the legislation that was recently passed. What happened was, in that legislation, all the current board members will be allowed to serve their terms that they have been appointed to. When those terms expire, then depending on what district they are from, then either the President Pro Tem of the Senate, the Speaker of the House, or the Governor will appoint that seat.
So that's an 8-year plan before that you could potentially have a board.
Well, it did reduce their terms to 6 years, and I believe there are a couple of the board members, the OTA board members now that are sitting on the board that their terms expire in the very near future. One of those is the governor's appointment, though.
Okay.
So that legislation will not have an immediate effect on the board. It'll have a long-term effect on how the board is appointed.
Okay.
So, yes.
What else can be done on your end now, since the bonds have been authorized?
That's what we're trying to figure out.
Yeah, what's the next step?
Yeah.
For you guys now?
Cry.
So the bond validation means that the OTA can build wherever they want. You know, they can build from Broken Bow to Enid, because apparently the legislative authorization doesn't mean anything. But our job right now is to keep pointing out inconsistencies within the Oklahoma Turnpike Authority business practices and bring those inconsistencies to people that can potentially do something about it. And one of the problems with the Oklahoma Turnpike Authority is there's no enforcement. So without any enforcement, you don't even have a constitution. There is no rule of law. If you don't follow what the law says, and you don't get in trouble for not following what the law says, then really why do we even have a constitution? So what our job now is to make sure that the Attorney General of the state of Oklahoma and the district attorneys in the different counties are aware of the things that are going on. And so we are in education. We've always been in education mode, but we're in outreach mode. We really need this audit to start kicking off, to find some things. Our insiders have been telling us things like the Oklahoma Turnpike Authority is now removing documents and removing electronic files to try to stop the auditor from finding things. And so we have credible information that we're willing to give investigative journalists to go investigate this, that there are things disappearing from the Oklahoma Turnpike Authority that would otherwise point to some interesting behaviors. And so our job is to keep shining light on this behavior and to keep telling the rest of Oklahoma that there is no place in the state of Oklahoma that is safe to build away from the Oklahoma Turnpike Authority. And they are not listening to legislative oversight, and our job is to instruct legislators to please improve the law to protect the citizens. We have eminent domain laws that are currently sitting in the Senate that we need Oklahoma to act on. We have Turnpike Enabling Act laws that we need the legislators to act on. They've been reticent to act on it because they're wanting to wait and see what happens. Well, now they saw what happens. It's like Tassie said, it's a very sad day for the state of Oklahoma. The citizens have no voice. The only way we can get that voice back at this point is through enforcement of the law, through the audit, and through changing the Turnpike Enabling Act.
I'll add too, I am still waiting for open records. I requested over a year ago. And even just enforcing the open records law, I think would be a big help, because as soon as information gets out in the public eye, the response is almost always, well, that can't be legal, or how can we do that? And so I think, again, these things are not unconnected, that they are potentially destroying documents, hiding information, and refusing to even acknowledge that certain documents exist that we know in fact do exist. So just having the truth out in the public eye, I think makes our work a whole lot easier. So we're grateful to the media for covering our story, and hopefully more will come forward that we'll be able to share with you soon.
And I want to add something too about the bonds. Even though the bonds were authorized today by the Supreme Court, as I understand it, again, I haven't read it thoroughly, the fact that there is an investigative audit in place and things are going on with that, I believe that taints the Oklahoma Turnpike Authority as far as the bond market is concerned, and I'm of the belief that they probably will not attempt to go to the bond market until that is cleared up. That's just my hopeful thinking, but my opinion.
And Tassie, did you want to talk about encouraging people to step forward?
Yes.
About that?
You know, again, in my prepared statement this morning, I had an eloquent little conclusion that I will try to reconstruct for you in my fatigued brain state. But on the whole, we've been very encouraged by the people who have come forward. And the information that they have shared with us has been very damning, and it's absolutely clear that there is a lot of unhappiness at the Turnpike Authority because of the increasingly autocratic management style of leadership. So we are hoping to speak out to individuals who feel this way and encourage them to contact the state auditor's office. Whistleblower laws do exist. There are protections. We'll be very happy to connect people with attorneys who can advise you of your rights. And I want to emphasize again that given what I know about the Oklahoma Turnpike Authority, for the employees, I want to tell them, do not let the management pin this on you. These kinds of failures are failures of management, and when discrediting information comes out in the public eye, they seem to have a reflexive desire to sort of blame a lower level person and not take that information as a reflection of their own job performance. But people who work there, I think, feel very differently, and those people I want to encourage to reach out to the state auditors, to us. We have abundant resources to share. And again, just given the little bit that I know about the internal dynamics, I feel very badly for people who are honest people who work there. I know there are quite a few, but now's really the time to come forward and share what you know.
How does the Supreme Court decision today affect the U.S. Bureau's of Reclamation decision regarding the illegally of the south part of the turnpike going over
Absolutely
to?
no effect. The Bureau of Reclamation is totally separate. The Bureau of Reclamation denied them access to those two, well, I guess it's three fee title land crossings that they proposed. In that denial, though, there is the opportunity, they said, that the Turnpike Authority could reapply, but that doesn't mean that they necessarily will. But at this point, they are denied access to those. We are not sure at this point whether they have just been denied access to the fee title land or the fee title land and the easements, depending on how that's interpreted. If they have to move that southern extension further west to avoid the fee title land, that would put it at least west of 72nd Avenue. If they have to avoid the easements as well, that would put it east of 60th. So potentially, or excuse me, west of 60th. So potentially that would affect a whole new set of people that live out in East Norman that thought they were free and clear from this boondoggle. So yeah, appreciate you asking that question.
And one thing to really pay attention to, when this first started, I went to the Bureau of Reclamation and a whole bunch of different people, and I said, you have to stop them now. Because if they start, you're never going to be able to stop them, right? Because they started the creek, they built over the creek, the waterway without the creek turnpike without a 404D permit. Then they sent their governor to DC to beg for forgiveness. So they do things, and that's what happened here. They spent all this money on design, then if you read the majority opinion, it says, well, they have this connection to make it the Kickapoo, and they have to do this, and it's gonna be a waste of resources if they don't do it. So the Oklahoma Turnpike Authority's MO is to go fast, get so far, so it makes the courts feel bad that they're wasting all these resources, when in reality it was their fault. It was management's fault. They made the decision to do it. They should be cut off. You shouldn't, in the dissenting opinion, the state Supreme Court Kuhn said that we made a mistake on the Kickapoo. It should have never been authorized. She admitted that in one of the paragraphs in her dissent. Just because they screwed up then doesn't mean they have to continue that screw up right now. And that's why the majority opinion was so wrong, because it's using all of these things that the Oklahoma Turnpike Authority has always done, start so fast, get so far, so no one feels like they can roll them back. And then, oh, I'm sorry, I built that bridge, I wasn't supposed to. I don't want to tear it down because then the roadway won't be used. Federal government give me the permit. And we really are hoping that the Bureau of Reclamation comes in strong right now and very soon and says, no, you can't do that. If you do that, we're going to do this injunction and stop and start them. If they wait to see what the OTA's move's gonna be, it's gonna be right where it's planned to be right now. So we're really hoping that the federal agencies understand the MO of the OTA, that they do things the same way all the time. And to bring up the point that Tassie was talking about, they have no traffic and revenue study. So in the Kickapoo, the trust agreement requires them to do a traffic and revenue study before they get the bonds. The Kickapoo traffic and revenue study wasn't completed until January of 2016, until after all of the right-of-way was gathered and all the houses were torn down. So it didn't mean anything. So they spent $1.8 million since February of 2021 for CDM Smith to do this traffic and revenue study on the southern extension and east-west. It's still not done. Yet they have all this right-of-way done. You see what I mean? So they do things backwards. So this traffic and revenue report that's required for the trust agreement to get bonds is not done. It's way over budget. It doesn't mean anything because a traffic and revenue study is supposed to tell you where to build a road, not written with a known route and all the numbers made to look like that road is going to be good. It's called reverse engineering and it's completely unethical.
We've had such a big question about that in our property. We have 14 acres that is destined, if this goes through, to be an overpass. Every bit of it, every single acre of it is gonna be mowed down unless they unchain me from a tree. But what we're wondering about is now it is a 4-lane that is being completed from Purcell to Noble. Why? Why is that right in front of this 14 acres that is supposed to be an overpass? Why are they doing that now if they're just gonna tear it down when it becomes a turnpike?
I'm just gonna go out on a limb, maybe a little undiplomatic. I don't think they're very smart people. And I'm sorry to say that out loud, but it just reminds me, it's what they used to say about the Watergate burglars. They're not very smart and they're in over their heads. But in the case of the OTA, the fact that we can all see this, but none of our people in power seem to be able to, that's what troubles me, right? Like, what they did with the Gilcrease also made no sense. What they did with the Kickapoo made no sense. And when that traffic study was completed, it showed, I believe, an estimated 4 to 6 minutes savings of travel time by building that highway. Is that worth $350 million? I don't think so.
Amy, did you find it curious that the Supreme Court's majority decision was referencing newspaper articles as their foundations of fact? I found that kind of odd.
Well, that was actually the foundation of Rob Norman's presentation to them. He had incredible historical research to validate his legal argument about, and again, I don't know if I remember all the particulars, but that, I mean, it was basically a historical argument saying that this was tried at a certain time and failed, and here's all this documentary evidence that it failed. And that was a big part of his presentation.
And that was in the dissent, actually, and they said that Rob Norman and Pike off OTA showed that the legislature meant for the outer loop to be one bond issue. And it said in the articles, one bond issue, and if you can't get in one bond issue, you don't build it. And that's what he was trying to show, that what the legislature meant, because that's what the Supreme Court was asking. Well, what did they mean? We don't know what they meant. And so those newspaper articles were used to build that argument, which is why the 3 dissenters came out extremely hard and said, it doesn't take rocket science to understand that the legislature said one issue and one issue only, and if you don't build it, well, too bad, too sad, you've got to go back. And that's why they tried to go back and get all the language changed in 1999, and they failed in the legislature. And that was the other argument, where we provided them the bills from 1999 that changed the wording of the statutes to try to get permission, and apparently the majority didn't think that that was important enough to rule in our favor.
Also, I want to point out too, at one point, and I haven't seen it lately, but on the Turnpike Authority's webpage, all of the turnpikes are listed in order of their construction, and every one of them says authorized by the state legislature, except for the Kickapoo, which says authorized by the Oklahoma Turnpike Authority, which indicates to me that the Kickapoo was never officially authorized by the state legislature, which
They changed it recently, but it still doesn't make sense.
Okay, but the point is that they went ahead and built that without the legal authorization of the legislature, and that is the only oversight anybody other than the Turnpike Authority has over the Turnpike Authority.
And what we would really encourage you to do, if you have more than 35 acres, we would really encourage you to talk to us about putting your land or portion of your land in conservancy. Because if you put your land in conservancy, it's federal conservancy, the Oklahoma Turnpike Authority cannot go through your land. We've been talking to several people in West Norman about this. So you need more than 35 acres. We can help you find the co-funding. So City of Norman will help to fund some of it. If your application is accepted, we can help you fill out that application. We've worked with several people already to get that working, but it takes a long time, right? So it is August 1st. I think the applications are due right around October, and you'll know if you were chosen in January. And so we've got to move. The application's not real hard, but we just need some information for you. We have people that will help you. That's one avenue, and also the City of Norman comprehensive plan is starting up, and we have some key people on that plan, and we're hoping that the City of Norman can put their feet in the sand and stop them and help us protect our water.
Do you know of anybody who's actually already applied to put their land in conservancy?
I do not, but I have a list of 7 people that I have sent the application to and that have expressed interest in it.
That does provide significant tax benefits also, doesn't it?
It provides, thank you, it provides significant tax benefits. So what happens is the federal government comes in and gives you money up front, and then you're eligible every year to get tens of thousands of dollars to do things like habitat retrofits and vegetation and wetlands. You build wetlands and things like that. So there's a ton of federal pluses to putting your land in conservancy. Now it can never be broken, so it's one thing that some children of aging parents are concerned about, because then the land can never be sold to be developed. It can be sold but never developed. And so, we feel like it's a really strong piece. You don't have to put all of your land into conservancy, just put 35 acres in, and it can really throw up some roadblocks literally to any new infrastructure.
Any other questions? Okay, well, that's a wrap.